Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update from the Supreme Court regarding the ongoing matter concerning divergence within the Calcutta High Court, specifically pertaining to the differences between the single and the division bench. Last week on 25th January, the Calcutta High Court Division Bench stayed a decision by Justice Abhijit Gangopadhyay, which ordered immediate transfer of a state-led investigation to CBI. This investigation was focused on admission of reserved category candidates to medical colleges allegedly involving improperly issued caste certificates. The division bench had put a temporary stop to the transfer, thus staying Justice Gangopadhyay's order. But ignoring this division bench order passed, Justice Abhijit Gangopadhyay on the same day called the order illegal and void ab initio while labeling Justice Somain Sen of the division bench an interested person in the matter. The next day, the Supreme Court took suo motu cognizance of the case. Further, in a special Saturday hearing, the Supreme Court stayed the proceedings in the writ petition before the single bench and the appeal before the division bench. Today, the 5-judge bench of the Supreme Court, presided over by CJI Chandrachud and comprising Justices Sanjeev Khanna, B.R. Gawai, Suryakant and Aniruddh Bose, decided to transfer the matter to the Supreme Court. Accordingly, the matter will now be listed after 3 weeks. Stay tuned. The Supreme Court has today extended the time for the Maharashtra Speaker to decide disqualification petitions filed by the Sharad Pawar faction of the Nationalist Congress Party against the Ajit Pawar faction. In October last year, the court had directed the Speaker to decide as per the 10th schedule of the Constitution the matter by January 31st, 2024. 2 days ahead of the expiry of the deadline, the Speaker approached the Supreme Court seeking 3 weeks additional time. Solicitor General Tushar Mehta said that since the Speaker was occupied with deciding disqualification petitions filed over the Shiv Sena rift, he is not in a position to comply with the timeline. SG said that the proceedings are otherwise over and the Speaker realistically needs 3 more weeks to dictate the order. The bench, comprising CJI Chandrachud, Justices J.B. Pardewala and Manoj Mishra, thus agreed to extend the time till 15th February 2024. The Supreme Court bench of Justices Sanjeev Khanna and Dipankar Datta today refused to entertain a petition filed by State of Andhra Pradesh against the High Court granting anticipatory bail to former Chief Minister and Telugu Desam Party President N. Chandrababu Naidu in the Inner Ring Road, that is IRR alignment scam case. Naidu has been accused of corrupt practices in the formation of Master Plan for Amravati, the capital of the state, and the alignment of IRR, purportedly designed to benefit entities and individuals associated with him. The charges, registered under various sections of IPC and Prevention of Corruption Act, pertain to the years 2014 to 2019 when Naidu held office. You already know that Naidu faces charges in 3 other alleged scams: the FiberNet scam, the skill development scam, and the liquor scam. Today, the Supreme Court heard the matter briefly before disposing it off. Naidu's lawyer, Senior Advocate Siddharth Luthra, informed the bench that the state government's plea against the anticipatory bail granted to co-accused persons in the case had been dismissed by the top court earlier. Justice Khanna thus said, as the allegations, the FIR and the set of facts were same in the cases of the co-accused dismissed earlier, the court would not entertain Naidu's petition now. The Mayor of Municipal Corporation of Delhi has filed a petition before the Supreme Court seeking a direction to exercise functions of its standing committee till the committee can be properly and legally constituted. The Supreme Court had previously reserved judgment on whether the Lieutenant Governor of Delhi can appoint nominated members to the MCD without the consent of the Delhi government. This matter arose from the Delhi government's petition to annul the notifications through which LG had appointed 10 nominated members to the MCD independently without consulting the Council of Ministers. Now, as per the Delhi Municipal Corporation Act of 1957, these 10 disputed members are also entitled to vote in the standing committee elections. Given that this will substantially impact the elections, the committee has not been constituted yet. Considering the functions performed by the Standing Committee are at halt, Mayor Shelley Oberoi, belonging to the Aam Aadmi Party, has moved the Supreme Court for relief. She has argued that several amenities have been affected. Some of them include the procurement of textbooks and medical supplies for MCD's schools and health centers and the maintenance of public parks and public toilets. Furthermore, the petition emphasizes that the corporation, being superior to the Standing Committee in both authority as well as responsibility, should perform the functions of the committee during its meetings. Also, the relief is sought only temporarily until the committee can be properly constituted. The Supreme Court today dismissed the petition filed by a former government pleader at the Kerala High Court seeking anticipatory bail in a rape case. The allegation is that he sexually assaulted the victim, who had approached him as a client in relation to another sexual assault case in which she was the victim. After the news about the sexual assault case surfaced, the petitioner resigned from the position of the government pleader. Today, the Supreme Court was hearing the SLP filed by him challenging judgment of the Kerala High Court refusing anticipatory bail to him. When Senior Advocate V. Giri, on behalf of the petitioner, attempted to suggest that the relationship between the petitioner and the woman was consensual, the bench disagreed, saying that the advocate was in the position of dominance. A bench comprising Justices Rishikesh Roy and Prashant Kumar Mishra dismissed the SLP today. However, considering a request made by Senior Advocate V. Giri on behalf of the petitioner, the court granted him 10 days from today to surrender before the police. And now an update on the Krishna Janmabhoomi Shahi Idgah Mosque dispute. The controversy is related to Mughal Emperor Aurangzeb era Shahi Idgah Mosque at Mathura, which is alleged to have been built over a temple at the birthplace of Lord Krishna. A bench of Justices Sanjeev Khanna and Dipankar Datta today heard the special leave petitions filed by the Mosque Committee and the Uttar Pradesh Sunni Central Waqf Board challenging an order of the Allahabad High Court by which it transferred to itself a clutch of suits over this land dispute. It also heard another SLP today filed by the Mosque Committee challenging the order passed by the Allahabad High Court in December last year, allowing appointment of a court commissioner to inspect the Shahi Idgah Mosque. Earlier this month, the top court had stayed the implementation of the Allahabad High Court order appointing a commissioner. The court today has adjourned the matter until April. The interim stay against the direction to appoint a commissioner was also extended till the next date of hearing. The Supreme Court today expressed surprise at the practice followed by the courts in Gujarat, giving the police liberty to seek remand of the accused even while granting anticipatory bail. The bench of Justices B.R. Gawai and Sandeep Mehta was hearing a contempt petition filed against police officials and a judicial magistrate in Gujarat after an accused was remanded to custody despite the order of the Supreme Court granting him interim anticipatory bail. Earlier, the court had come down heavily on the police officials and the magistrate for violating the interim order and issued contempt notices to them. Solicitor General Tushar Mehta informed the court today that departmental action against the officer was underway. He further appraised that it was a common practice in Gujarat for bail orders to include a condition that investigating officer would be at liberty to apply for remand. That under this mistaken belief, the officer in the present case had applied for remand of the petitioner, which was permitted by the magistrate. The court, while expressing surprise, said that such a practice would defeat the objective of granting anticipatory bail, nullifying the guarantee of personal liberty. The bench observed that proper training must be given to the judicial magistrates in the state and added the High Court of Gujarat as a party to the present proceedings. Notice was issued to the High Court through the Registrar General. Last week, Rashtriya Janata Dal leader Tejashwi Yadav had told the Supreme Court in an affidavit that he had withdrawn the remarks made by him about Gujaratis. As you are aware, a criminal defamation case was filed against him in Ahmedabad for his remark that only Gujaratis can be cheats. made during a media address in March last year. Referring to the statement filed by Yadav in court regarding withdrawal of his statement, the respondents' counsel contended that his remarks were meant to harm the entire Gujarati community and that his present statement was not clear and not satisfactory. Thus, the bench of Justices Abhay S. Oak and Ujjal Bhuya sought a simple and clear statement from Yadav and granted him a week's time for the same. And lastly, the Supreme Court has issued a significant order stating that the caste or religion of parties should not be mentioned in the memo of parties in petitions or proceedings filed before the courts. This direction was given during the hearing of a transfer petition related to a family dispute between a husband and wife where the caste of the parties was mentioned in the memo. Expressing dissatisfaction, the court emphasized the need to shun and cease the practice of mentioning a litigant's caste. In response to concerns about altering the memo of parties, the petitioner's counsel explained that the registry might object if changes were made. The court clarified that the directive applies regardless of whether the caste or religion of the parties was provided in the courts below. In October last year, a bench led by Justice Abhay S. Oak had also criticized the practice of mentioning the caste or religion of a party in the cause title of judgments. Today, the bench of Justices Hima Kohli and Asanuddin Amanullah, while issuing the significant direction, also said that in order to ensure immediate compliance, a copy of its order be submitted to the relevant registrar and circulated to the Registrar Generals of all high courts. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.